Hello, everyone. Thank you for joining us this afternoon. We're going to start in just a moment. We wanted to let everybody get into the room. All right, good afternoon, everyone. I will get started with some logistical notes for each of you as folks start to trickle in. Let's see. My name is Chell Miller. I'm the publications editor and events coordinator at the Government Law Center. This program, excuse me, I'm going to stop sharing my screen for now. This program does have live automated captions, and you will be able to turn those on by clicking the live transcript button at the bottom of your screen. If you have questions for our guest speakers, please hold them until the Q&A portion of the program. If you're here on Zoom, you will be able to click the Q&A button at the bottom of your Zoom window to type in your question. Our CLE forms and program materials have been sent via email. If you have questions about obtaining CLE credit, please email Lisa Rivage, and I will add her email address to the chat box. The chat box will be disabled for attendees today. That will reduce some clutter. I will share some important notes for you all, and that way the hosts and panelists can send notes to each other during the program. If you have any additional questions, you are welcome to email me. I will put my email address in the chat as well. And with that, I will turn it over to Judge Stein to kick off the program.
Good afternoon, everyone. I was just keeping an eye on how many participants we have. We have well over 100 already on this call, so that's really exciting. I'm here to welcome you to the fourth installment of the 2023 Disability Law Series on Civil Rights and Individuals with Developmental Disabilities. I'm Leslie Stein, Director of the Government Law Center and home of the Institute on Aging and Disability Law. This is the fourth program in this exciting series. As you might expect, these programs have been organized by a number of individuals. Special thanks to the members of the Aging and Disability Law Committee members, Lawrence Faulkner, Paul Keatsman, and Sheila Shea, led by our own Professor Rosemary Bailey. Also, many thanks to the GLC staff members who have handled the arrangements for this program. The topic of today's program is challenges in guardianship for people with developmental disabilities and strategies to address them. The final program of this series, there is a program which will be presented on April 13th and will address potential statutory reforms for the protection of civil rights of people with developmental disabilities. Before I introduce the moderator of today's program, I want to remind everyone who is seeking CLE credit for the program to complete and return the affidavit, which you should have previously received. And there will be 2 code words announced during the program, which must be set forth in that affidavit. And now on to the program. We are fortunate to have Lawrence Faulkner as the moderator of today's panel. Before his retirement, Mr. Faulkner served as the General Counsel and Director of Corporate Compliance at the ARC Westchester. He was instrumental in the drafting and passage of the New York Healthcare Decisions Act for persons with intellectual and developmental disabilities, which gives guardians the authority to make healthcare decisions, including end-of-life care. Mr. Faulkner also previously served as Deputy General Counsel at New York State OPWDD and as Director of Legal Services for the Elderly in Buffalo, New York. We are very fortunate to have Mr. Faulkner with us today, and he will introduce our exceptional group of panelists.
Thank you. I'm on. Okay, thank you. let me do that first. Let me introduce our panelists first, and so you know whose pictures you may be looking at while we're talking here. We have with us today a group of individuals, most of whom I have worked with for years on a variety of issues connected with the rights and services provided to individuals with developmental disabilities. And I cannot be more honored than to be in this august group. Rosemary Bailey, who oversees the Institute for Aging and Disability Law at the Government Law Center of Albany Law School, and is also an adjunct professor of law at Albany Law School. Julie Friedman, who is managing attorney for the Albany Regional Office of the Mental Hygiene Legal Service Program. Lisa Friedman, who is an attorney in private practice in New York. Her primary areas of practice in this area are future planning for people with developmental disabilities and individuals and family members who are disabled, as well as elder law. The Honorable David Guy, surrogate, Broome County Surrogates Court in the 6th Judicial District, New York. Kate Jerian, Deputy Executive Director and General Counsel for the ARC New York. She practices mainly in the areas of disability, guardianship, and not-for-profit corporation law. And Chris Lyons, who is Chief Executive Officer of Ames Services in Saratoga. As we go into discussion of 17A, we've had a lot of discussions about medical care decision-making and other issues in the previous panels dealing with issues concerning individuals with developmental disabilities. As we go into this fundamental area of guardianship, we're talking about the rights of people with disabilities and the due process rights and other rights that they have in a set of proceedings, which are often commenced to have somebody else given the authority to make decisions for them. A recent article by our own Sheila Shea at Mental Hygiene Legal Services was entitled, for the Bar Association Journal, was entitled Protective Orders and Limited Guardianship, correction, was entitled Guardianship, Article 17A, Marooned in Time and in Need of Reform. That word marooned, I think, kind of putting parentheses around it, that word kind of indicates what we're going to be talking about today. And as we go into that discussion, I'd like all of us to think back, if we're old enough, to think back to 1969 when 17A was passed and what the attitudes of the state and of the family, not the family so much, but to some extent the families, and there were no service providers, but those who were concerned with the rights of people with disabilities were at the time. And there were advocacy groups, also parent advocacy groups. In 1969, we were using the word mentally retarded, not developmentally disabled, and we referred to these individuals as retarded. We referred to them as children for life. They were considered children for life, and therefore the placement of 17A was logical. It was in the statute that deals with guardianship of minors. They were never expected to be anything but children in the legal sense that needed an adult to make decisions for them, such as we do for minor children today. There were few services in the community outside of institutions, few, if any, services outside of institutions, whether they be educational, whether they be job-oriented or job training-oriented, or whether they just be even day school, daycare. There was nothing out in the outside world. In many cases, parents therefore had a choice. They could either keep their child at home, as we used to say, in the closet. They could keep their child home, or they could have him or her put into a developmental center. And in many cases, these parents were advised to do that upon the birth or discovery that a young child was developmentally disabled, because it was considered better for the other members of the family and for the individual. But we know what those institutions historically became. That's what it was like in 1969 when the statute passed. And as such, the statute was a tremendous tool for families. It provided them with a sense of bringing their child out. It provided them with a sense of control or decision-making authority when the child reached 21, which is now equivalent to the age of 18, to make decisions, to make healthcare decisions, to make other decisions. We later learned that healthcare decisions needed 1750B to be put in place, but that was later. So it was a tremendous tool at that point, but we are no longer in 1969. Things have happened since then, and we've had a great development in the field of how to treat people, how to integrate people into the community, and we no longer do we look at developmental disabilities as an all or nothing. You are either developmentally disabled and you need a guardian, you need somebody to make decisions for you, or you're not. We look at people as individuals with a variety or scale of disability. In 1990, we began this process that brings us to today. In 1990, OPWDD, which was then OMRDD, OPWDD was charged by the legislature with doing a study of guardianship under 17A and whether or not the changes should be made. The Office for People with Developmental, Office for People with Mental Retardation at the time is the term, conducted studies around the state, hearings, met with judges, surrogate judges, etc., and came out with a draft report. That report was never filed with the legislature, but that was the beginning of the discussion of needed changes to 17A. In 1993, now we're talking 30 years ago, it's the anniversary this year, 30 years ago, Article 81 was passed, which was a guardians and conservatorships and committee of the incompetent were revoked. It was a movement towards recognizing the individuality of people with disabilities. It was tailored, it is tailored to the needs of a particular individual. It provides right to counsel, right to a hearing, etc. It provides for reporting by the person appointed as guardian. And in many cases, it became a model against which we began to measure 17A, for good or for bad, against we began to measure 17A. In addition, as you see, we've had a whole series of alternatives to guardianship developed. We have the Healthcare Decisions Act. We didn't have that in 69. We have the Healthcare Decisions Act, 1750B. We didn't have that for persons with developmental disabilities. We didn't have that in 1969. We have healthcare proxies. We didn't have those in 1969. And of course, we have Article 81. So as we sit here today, we should be looking at Article 17A in the context of what we now have, the tools we now have on hand, and whether or not 17A is still appropriate for those who are in need of some kind of guardianship proceeding, whether it be plenary and all, or whether it be more tailored to the individual needs, depending on the level of disabilities. And I hope that today helps us all begin to think out that process, look at what was developed, what's been developed, and the proposals that have come from the Law Revision Commission, from the Surrogates Court Advisory Committee to the Office of Court Administration, from the government, well, not from the, I said the Law Revision Commission, and look at how these affect what we're talking about. So I'd first like to begin this discussion by asking the same question to all of the panelists in turn, to take a shot at answering it. And then we will go into, if we have time, some more specific questions around specific due process issues. And that question that I'd like each of you to think about and talk on is, what are the civil rights challenges people with developmental disabilities face in guardianship appointments? From the panel, from your perspective, as an advocate, a judge, service provider, a guardian ad litem, or a lawyer for petitioners. I'm doing this in alphabetical order. There's no favoritism here for how I'm going to go through people, but I'd like to ask Rosemary Bailey to make the first response.
Thanks, Larry, and thank you all for inviting me to be part of this panel, and thank you all for joining us today. I think, as you've heard from Larry's remarks, this is a dialogue that's been going on for a long time, and it's my privilege to have been part of it. So I thought I'd start out by just saying what I've identified as the civil rights that are located in guardianship proceedings. And the first one is that there's a right of a person to function independently and make their own decisions. And I think we all recognize that. And in fact, the New York State's public policy recognizes that. If you look at the mental hygiene law, its stated purpose of OPWDD is to promote independence of individuals with disabilities. And in fact, their regulations say that no person's civil rights can be impaired by virtue of a diagnosis of developmental disabilities. Over the years, through the various writings by the President's Commission on People with Mental Retardation back in the late 60s, early 70s, the ABA and others have come to recognize that in guardianship, that person's right to make their own decisions should not be infringed upon by the appointment of a guardian unless it's absolutely necessary. And that the person should be permitted to make decisions of which they are capable, and the statute should recognize that, which leads to a tailored appointment. Also, that if there's a determination that the person needs assistance, that it should be the least restrictive alternative that is imposed on the individual. And I think that the challenges that we face in New York right now is primarily the guardianship system itself, because as Larry pointed out, we have these two statutes and they have not only different purposes and origins, but different provisions. And yet Article 17A, which has fewer provisions regarding protection of an individual who's subject of guardianship, is the more popular statute. Article 81 covers people with developmental disabilities, but it's rarely used. Article 17A focuses on medical determinations, and there's no option for the individual who's the respondent in an Article 17A proceeding to convert it to an Article 81. As I understand it, they would have to seek a dismissal of the Article 17A and then go to the Supreme Court and can have either seek to have their petitioner commence an Article 81 against them or petition themselves for an Article 81 guardian. So that puts them at a distinct disadvantage right off the bat. There's no statutory requirement that less restrictive alternatives be considered. There's no statutory requirement that there be a term limited guardianship. And I know that Judge Guy was gracious enough to share with us a list of cases that illustrate how the courts have been addressing those issues, but nevertheless, the statute is silent on them. And finally, there's no post-appointment process for assessing further need of a guardianship or whether the guardian is receiving appropriate support in delivering guardianship services to the individual. And there is no stated opportunity for the individual to know that they can seek restoration from the guardianship. So those are the challenges that I see, Larry.
Thank you. Julie?
Hi, thank you, and good afternoon, everybody. It's great to follow Rosemary Bailey because I think she gave a great overview of some of the issues with 17A. Now, my agency, Mental Hygiene Legal Service, we are frequently either a guardian appointed as guardian ad litem for the respondent in a 17A, or we can be counsel. And on the Article 81 side, we're often counsel or court evaluator. And in very rare cases where we feel it's appropriate, we're petitioner, but that's very rare. I want to talk, hopefully I won't be too repetitive of some of the issues that Rosemary brought up, but I want to sort of share, I think, a perspective that I've gained over the years of doing really 17A, since that's mainly what we've been talking about. I think as Larry had pointed out, the statute is sort of predicated on an assumption of a level of disability, that someone has a diagnosis and therefore they're in need of protection and in need of assistance. It's very diagnosis driven, as opposed to Article 81 or some of the proposals that have been summarized and referenced in our materials, where it's talking about a functional approach and functional limitations. So it's very diagnosis driven. And as a result, that we have this real disparity in the way our clients who are subjects of 17A are treated in terms of the court process. So just to talk about the process and where it usually starts, it's usually parents or close family members who are bringing the petition. And my belief, and I wasn't a practicing attorney back in the 60s, but that that the statute was really intended for people who had profound and severe disabilities and limitations. Even the definitions of developmental disability or intellectual disability are much different than they were years ago, and there's much more of an acknowledgement of that sort of continuum of need. And so what we often see is a well-meaning family member, often of a young adult, but sometimes we've seen it of someone who's in their 40s, who has a diagnosis that fits into that box that's going to fit into a 17A. And they bring this petition, and the individual may have mild impairments, but the family is sort of seeking a degree of protection, or maybe they've been told they need to do this. And 17A really can be overkill. You know, the guardianship doesn't really, the statute doesn't point to narrowly tailoring decision-making, as Rosemary pointed out. And so we have a guardianship decree that sometimes I've said is says nothing and everything at the same time. So if you were appointed guardian under 17A, well, maybe you have the ability to do everything. But it's not really very specific. And so if it's a high functioning individual who's capable of voicing their opinion and making decisions, maybe the guardian's power is really illusory, and maybe they're not really, you know, doing anything at all. So we get stuck with that sort of, you know, what does this piece of paper mean? The civil rights challenges that we have seen are things like someone who is quite high functioning, but finds out maybe later in life that their parents applied for disabilities. They were able for the guardianship. The individual had some type of disability. And because when the certificates were filled out, which is a requirement, which is a predicate for bringing the action, the doctors indicated that the person, harm might come to them if they participated in the guardianship proceeding. So we have a generation of individuals, many of which don't even know that their parents had obtained guardianship over them, because there was a determination made, or opinion, I should say, by physicians that maybe they didn't even need to appear in the proceeding. And if there was no counsel or guardian ad litem, then their participation could have been excused by the court, without the court even having an opportunity to get more information other than what's in the medical certifications or what the parents stated. And so we've had situations where someone is getting married and maybe they want to have a child, or their family members their parents or guardians have passed away, but a sibling or a cousin or someone they may not even have a real relationship with is now saying, oh, I'm going to be your successor guardian. We've had clients who live on their own, they live independently, they work, they take care of themselves. They might get some assistance through OPWDD services, but they're very independent. And now they feel like they've been, shackled with a guardianship. I think also at the petition stage, some of our clients who are high functioning enough to understand the proceeding and what their options are might feel that they're faced with an impossible choice. Their family members, who they may have a very good relationship with, who they may live with, want them to consent to a guardianship because they feel it offers a level of protection. And the individual might not feel that they want or need a guardianship, but they also don't want to be put into an adversarial position with their family, who they might rely on for assistance and who they might, love very much. We have in a number of cases been able to work out things that are less restrictive, to point out to families that maybe you don't need a guardian, maybe you need something that looks like supported decision-making, or a healthcare proxy, or a HIPAA release, or a seat at the table for decision-making that's going to happen. But sometimes we get resistance from families or from their attorneys or from the agencies working with the families who say, no, the family needs this. This is absolutely essential. They just want to protect their family member. They're not looking to interfere with their independence. And so I think those are some of the things that we see, that it's using a very blunt instrument in order to assist someone with decision making. And the statute, you know, as we've heard, doesn't really require looking at least restrictive alternatives. And so, you know, those are some of the problems that we see with 17A. You know, 81, as Rosemary pointed out, Article 81 relies on that functional analysis, and you can narrowly tailor it, and you can really come up with creative solutions. And I feel that with 17A, that's really really much harder to do. And we see it, I guess, just to conclude, we see it in a lot of cases where we feel that it's not really appropriate, where there might be something else short of a 17A guardianship or short of a guardianship itself that might be more appropriate for someone with a disability. So I'll stop babbling and let somebody else take a turn. Thank you.
Thank you. Lisa?
Of course, I'm in Manhattan, so you can hear the music on the street. So I apologize. Hopefully the car will drive by in a minute. From the perspective of the petitioner, you know, as petitioner's attorney, people are coming in because they're often told, or they're often working on their financial planning for the individual, and guardianship is added in there as something that needs to be done. And 17A is easier and cheaper to do. So certainly that's where people are sent. You fill out some forms, they get filed, you fill out a few more forms, and you're going to go have a hearing in front of the judge. Depending upon what county you're in will determine how actively involved the court is in it, or whether you get your papers. In the olden days, back when I started practicing, the certifications from the doctors or doctor and psychologists were 2 lines long. The person needs a guardian. Now things have changed, and we're now checking boxes and filling in little boxes. And this certifications give a little more information, but they're easy to do. What's difficult is, in theory, you shouldn't, the petitioners shouldn't be able to get the doctor and psychologist certifications completed if the child is over the age of 18. And courtesy of the schools, and they say, as part of their easy transition planning, they check the box and say you need to go apply for a guardian. Not fully understanding what that's going to mean in the end. And it's 100%, and the parents want to continue, as has been said already, they want to continue childhood, and it's perpetuated because they're protecting the individual. So my job as counsel for the petitioner, I believe, is to explain to people that it's not like it was back in 1969 or 1970 or 1990, where it was easy to get through. You fill out your forms, you show up in court, and you're done. From one county to the next, the courts are more involved in the process. So that if you go look at all the cases that were provided with your materials, there's been an evolution where courts are looking at whether or not a full guardian is needed. And going from one court to the next, you're going to have, you may have variations on the order the decree appointing the guardian, but it's generally either time limited or there may be some other limitations, but there really aren't many. So I think it's important that petitioner's counsel explain to their client that it's not open and shut anymore, and that the Article 81 needs to be reviewed with the family as well. And as Rosemary said, you can't go from one court to the other, or you can't do an 81 in the surrogate's court. So it creates a problem because petitioners like 17A because it's cheaper, because you're filling out forms and the individual can do it themselves. So I think that's about all for now.
Okay, thank you, Lisa. David Guy, Judge Guy?
Yes, here I am, and I unmuted so people can hear me, I hope, right?
Oh, yes.
Okay. Well, thank you, Larry, for moderating, and thanks to law school for having this series and for having me be a part of this panel. I appreciate it. I enjoy the opportunity to talk about guardianship generally and 17As and 81, both because I actually do both cases, both types of cases, I should say, as many of the upstate surrogates do. I do Article 81s as an acting Supreme Court judge. I do them in the entire district in which Broome County is a part. So it's a 10-county district, but my 10 counties together don't equal the population that Lisa has in her county, for instance. So volume is an issue. At the same time, the surrogate court in Broome County does not have a dedicated guardianship part as the busier downstate counties do. But so from a volume perspective, I don't do a lot of 17As. I see more than one a month, but less than two a month. 17As are, though, a very frequent topic of conversation when the surrogates get together. And I was wondering what you call that. You know, when it's a bunch of crows, it's a murder. I suppose we don't want to call it a murder of surrogates, but the surrogates are a small group. There's only 83 or 4 across the state total. And some are sole surrogates, many, the majority are multi-hatters. I'm elected as a surrogate, but like many of those of us who are, I do Supreme Court work. And in my case, I'm lucky, I just do Article 81s and also Article 9s. But we talk about 17As a lot. And so my perspective is kind of impacted by the fact that I deal with 17As, I talk about them more than I deal with them, and I also do 81s. So I see the contrast between them. Just as a point of information, I do more than 180 Article 81 a week. So many more. And since 2020, we're up at least 20% in the number of Article 81s we see. So we're definitely seeing an influx. So the earlier speakers have talked about what the constitutional infirmities are. To restate them, because I think it's important to do, there, from a legal perspective, there is no right to counsel. There is no right to a hearing. Those things can happen and sometimes do happen, but they do not have to happen. There is also the result of a 17A is a plenary removal of rights. And I think one of the infirmities is also I'm going to call it the clinical proof standard, which as Lisa and Julie and Rosemary have all said, it is based on diagnosis, not functionality. So, it's kind of like getting a violation. If you're parked too long in a parking space, you can get a ticket, and all it takes is evidence that you parked there too long. If you have 2 certifications that say you have a developmental disability, you can be subjected to a 17A. Now, in the same way that if you're over the space limit in a parking lot, in a parking space, you are, you can't argue with that, and you maybe a ticket is appropriate. And in many cases, 17A is an effective and not only well-intentioned, but well carried out resolution to the issues that a person with developmental disabilities may have. But as I think Julie said, it is a blunt instrument. So as Julie said, in the case where you've got somebody who has profound and severe disabilities, a 17A may be the best solution, and it may, despite its constitutional infirmities, may not be problematic. But for the surrogates, navigating or synthesizing all these issues is, what we're tasked with doing. And don't forget, we sit in a court of equity. As Lisa points out, the surrogates are much more involved. The courts are more involved through their guardianship parts and through their surrogates than they used to be. So what has happened, and there's the list of cases that's in your materials, is surrogates have found ways to kind of navigate around these civil rights problems that exist in the statute. We very frequently will appoint counsel. Many times it will be mental hygiene legal service, although that option is not available across the state. I am lucky to be in the third department where Julie is, and we never have an issue getting mental hygiene legal service to serve for us in these or other areas. They don't have the manpower, honestly, to do that everywhere. We also, on a very limited basis, are appearances waived anymore. Now, I did not say hearings are held in almost every case, but appearances are not waived on a frequent basis. I, like many of my colleagues, even when the certifications come back and the box is checked that the person cannot appear or should not appear, we follow up with the families and try to understand what the rationale for that is. And if it's just a kind of a knee-jerk check of a box by a well-meaning physician or psychiatrist, we will ask folks to come in. And these days, we ask folks to come in virtually if they're not comfortable coming in live. And in many cases, it is helpful to see folks in their home environment. And it's easier and better in many ways to have the appearances that way. So we do, I'll call them more informal hearings more often than not. I have not had one of the cases that you see reported, in this list before you, but they are cropping up around the state. There are obviously more of them in the downstate areas. So the courts also have to be, and I think try to be, sensitive to the perspectives of the other players who are in these proceedings. The parents' counsel, like Lisa, they're trying to be for their clients, the parents, as efficient as possible from a time and a money perspective. And there are many families for whom hearing that a 17A is not in their child's best interest and an 81 is what they need to be pursuing are not realistically in a position to actually do that from a time and money perspective. Now, that doesn't mean it's not the appropriate response sometimes, but the courts can't be insensitive to that issue. Also, from the perspective of the advocate for the ward. So when I get one of Julie's colleagues in front of me who, having met the ward and the ward's family, has her antenna up, I'll say, or has perceived some issues, they may be wanting to push the family to a higher level of proof, I'll say, or a greater showing to the court as to why a 17A is appropriate. So we have to balance those factors in trying to manage these. And it is, as Rosemary says, the statute is silent. And so the confidence level that you have where constitutionally appropriate procedures are mandated is not present in a 17A. It would be better constitutionally to have those. At the same time, having flexibility in the courts is also a good thing. And we're going to talk about that more when we talk about alternatives to guardianship and the proposed legislative changes. So I think I'll leave it at that, and we'll touch back on some of the issues in back. Thanks.
Thank you. Kate?
Hello, everybody. Just going to share a couple slides to break some things up here. Move my. Okay. You can just call me the flip side of the coin. That's the role I'll be playing today in this. And I really want to focus my comments on making sure people understand the realities of what it actually is like to administer a guardianship today under 17A, how it really works. And I agree with Larry, at times certainly have changed since the statute was put into place in 1969, but that doesn't mean that the guardianships are being administered in the same way that they would have been in 1969. So I just want to share that point of view. So the ARC New York, just for everybody's edification, is a nonprofit. We've been around for almost 75 years. We have a long history with guardianship under 17A, and I'll get to that shortly, but our families really were some of the first to be advocates for people with IDD before there even were services. So we are famous for a mom in New York City putting an ad in the New York Times looking for other families who had children with disabilities so that they could network and develop what really has turned into the system of supports today. Our organization was also a lead plaintiff in the Willowbrook litigation, and today we're governed by our boards are a majority of family members and also people with disabilities, self-advocates and others. And seeing the need for a decision-making structure, the ARC New York families really were ones who took the lead back in the 60s to advocate for the passage of 17A. And as Larry said, that was 20 years before 81 came into being. So nonprofits like the ARC New York have authority to be the guardian only of the person, not of the property. And our organization does that. We have a pretty robust guardianship program. We serve as guardian for about 550 people in New York. And you see the breakdown there, about 300 primary, and then another 250 in a standby or alternate capacity. There is no public funding for this service. There's a greater need than we can even support, which is that there are people who don't have family, who don't have support systems, who need guardians. And we do this, without funding. We have a policy where we don't accept individuals unless guardianship 17A is a last resort, meaning that there's no available or appropriate other family member or friend, and obviously that there's a need for the guardianship. So I looked back at the bill jacket for the 1989 amendment that Larry discussed before, and some of the themes that are coming up today in the comments of those who spoke before me really were present back then. And I think a way of looking at 17A guardianship as a support to people's civil rights is something that hasn't been discussed so far. And, again, those reasons, several decades old at this point, admittedly, but really were to promote the health and welfare of individuals, to provide long-term protections, to advocate for appropriate care and treatment, including medical decisions, and a recognition from the New York State Office of the Advocate for the Disabled at the time that there were a large number of individuals who had no support at all, and no assistance making decisions. And another organization's letter in support that feeling like guardianship was important to support independence actually and protection, not as sort of a takeaway. And I think, today, like I said, and I'm not sure who keeps those statistics, I'm not even sure the state knows, but there are a lot of people who don't have capacity, who don't have guardians or other advocates to help them. And interestingly, there are sort of a long list of other legal avenues to make decisions without guardianship, because there's a recognition, I think, that decisions need to be made and not everybody has a guardian, right? So, things like informed consent committees, which are at the provider level that allow for things like COVID vaccines and other types of approvals. Right now, the state and the federal government is requiring every individual who served in a residential capacity by voluntary providers and others to sign an occupancy agreement. It's kind of like a lease, and they recognize again that because that's required, but not everybody has a guardian, those have to be signed by your individual representative. And then there's other things like medication administration and other informed consent that can be done without guardianship. So from the practical perspective, I just want to make sure that folks are aware of the sort of the state of the field of disabilities right now, what sort of struggles that families and individuals that we support are facing. If you take a look at OPWDD's website, they have some pretty interesting statistics about, you know, the age and the types of folks that are receiving services. It's increasing every year, the number of people that are diagnosed, the number of people that need services. Right now, there's about 9,000 folks who are over 65, and in our guardianship program, actually, we're a little bit older than that. We have about 70% of the people of those 300 that I mentioned before who are over 60. So, you know, there's an aging population. At the same time, there is a persistent and long-term workforce crisis. It's been happening for at least a decade, but right now, 1 in 5 direct care positions are vacant. And the average starting wage for folks who support individuals with disabilities in the nonprofit sector is just above $16 an hour. So the ability for individuals to get out into the community to receive some of the services that they need is significantly reduced right now because there aren't enough staff to support them. And I think provider, you know, instability is up in general due to this, and as well as inflation. So it makes it a struggle. So in the over 10 years that I've been here in our guardianship program at the ARC has been going on for many more decades. In addition to that, I've seen a lot of fact patterns, which hearing other speakers might make you think that there's sort of guardianship under 17A is not a helpful tool, perhaps, or it's certainly not an optimal tool. And we don't disagree that there are changes that could be made, but here are some of the things that we see guardianship doing to support the civil rights of individuals. For folks that have a 17A guardian, you know, having medical care. We all know when we go to the doctor's office, it can be confusing. There's technology, there's forms you have to fill out. You have to make sure you get enough time with your physician to ask the questions that you need asked and have follow-up. Those are all things that guardians under 17A, at least in our program, do, and I'm sure others that are, you know, 17A guardians as well. You know, just making decisions about procedures, advocating for professionals for treatment. Some of the other things that 17A guardians support are things like making sure that people are getting the services that they need so that they can be as independent as possible, right? And their quality of life can be as good as it possibly can be. Sometimes that's not something that happens without the support of a 17A guardian. Guardians in general, and certainly in our program, I know, make sure that the person is recognized, right, and celebrated the way that any other person would like to be. Birthdays, holidays, making sure they have appropriate clothing, making sure that their residential environment is appropriate and comfortable, and making sure that they're going out into the community and having their you know, wishes met as much as possible. And then the last item, I think, is something that we've seen far too much, and I'm sure everybody on this call can agree with the staffing crisis. There have been a lot of cases of individuals who have been, you know, placed in restrictive settings that are too restrictive, in nursing homes, or they're in a hospital for an extended period of time and can't get out. And the guardians do provide an important role in advocating and making sure that, you know, those options are limited for folks who are stuck in those situations, and that they're, you know, receiving the least restrictive care. So with all that being said, I would say that our organization, like I kind of said at the beginning, although 17A is from the 1960s, our organization has certainly evolved. If you have a link to these, if you have these materials, which I believe were in the packet, that underlined position statement will take you to our website, which gives you a sense of at least our position. And it's pretty inclusive. I mean, we recognize that a core civil right is to make your own decisions. And I think in 17A, as Julie said, it can be a blunt instrument. It can be all of nothing. We learned, which is that you can have a plenary guardianship order and you find out that you can't sort of force a decision, right? Or you can't compel the individual who's receiving the guardianship to really do much of anything, which kind of counteracts the perspective that it can be sort of overbearing. But we always support the right of individuals to participate in all decisions. Just because you have a 17A guardianship doesn't mean you don't make any of your own decisions or you don't participate in your decision making. And we recognize that, and certainly there are, now since we've started, I've been involved in this conversation, we've got supported decision making and other tools to help folks that are less restrictive than guardianship. And we also believe that guardians should support the removal or a tailoring of authority if that's appropriate. So I think, it's a practical conversation as much as it is a conversation about legal rights, but I think there certainly, and I've said this many times before, that a couple of bad apples can certainly spoil the bunch. And I think we've all seen situations in which individuals may have guardianship being used as a tool to kind of, control or take a position, but it can be also used in a lot of very positive ways. And I think during a time when supports are limited and parents are overwhelmed, supporters are overwhelmed, to make things more difficult for individuals to get the support that they need, is not really a good thing from our perspective. Again, changes certainly can and should be made, but there's also the reality of the situation and the services that we have now that need to be recognized.
Thank you, Kate. Chris Lyons. Chris.
Thank you, Lawrence. I'd like to thank the law school and Judge Stein and Professor Bailey and the Government Law Center for the opportunity to talk to you folks about guardianship. As a alum and former member of the Board of Trustees, it's great that the law school is covering these interesting topics in such an interesting, comprehensive way. And what a great panel too. So I have a pretty diverse background in this field that I'll outline real quick. I currently am the CEO at AIM Services, which is a large not-for-profit agency based in Saratoga that covers the entire eastern part of the state from Canada to Long Island, with a diverse of services for people with developmental disabilities, acquired brain injury, legacy traditional services, residential, day supports, supported employment, some of the things that you might know of as group homes and things of that sort. But we also have self-directed services and a wide variety of other services for the thousands of people that we support. I was a trial attorney by trade, partners in a litigation firm, and I did litigation across the country post deinstitutionalization, defending individuals and provider agencies, promoting the least restrictive environment. But I got to spend a lot of time with agencies, and then joined AIM. And as the CEO, I am Guardian, as Kate pointed out. We do act as Guardian, a much smaller number than the ARC. But I also have had the privilege as of counsel to affirm part-time to file, oppose, and seek to restrict all kinds of guardianships. My role as a provider, we are put on notice if we're providing certain level of service to someone about guardianship. I've teamed up with MHLS on many occasions to suspend, restrict, rescind guardianship, restoration petitions. So all of that is from the legal end, but I'm going to talk to you a little bit just from the straight provider end and my experience with families and the thousands of people I support. First, let me start with a couple of things. You heard about Willowbrook and the shifting paradigm of service delivery and how we've come from mental retardation to just people with challenges. There has been a major shift from the control model to the support model and people with intellectual and developmental disabilities. It's more extent now than it ever has been. And I think that the panel has outlined that we've moved along as best we can under the guise of 17A to support that changing paradigm. But about 2 to 3% of the population have an intellectual or developmental disability. Of that percentage, 90% are I hate to use the mild, but they're considered mild in their cognitive deficits, which means you wouldn't really be able to immediately recognize them as having a developmental disability. Of course, in today's age, you can walk down the street and somebody's talking to themselves and you say that person has a mental health issue, or maybe they just have earbuds in their ears. I don't know. It's hard to tell these days. It's a hopefully we're broadening our spectrum of how we view people as people and transcending challenges. But I do have a great deal of sympathy for those families who have a loved one. And for us, it's usually an adult that we support who is significantly challenged and needs a 17A because they need almost all the decision-making substituted for. We promote independence even with those people. They may be nonverbal, but they still have a voice. Behavior is communication. We support profoundly challenged, medically fragile people and treat them as people, but they do need a guardian for day-to-day services. As Kate pointed out, you cannot cut through the system without a guardian for the profoundly challenged individual. And then you get to the people who are aging out. And as I think Lisa or Julie or somebody mentioned, unfortunately, and it's changing, high schools and people involved in transition from their independent educational plan to adult services, one of the check boxes is get guardianship. And that gets to the ability to get that control versus the need to get that control. So many parents are confronted with this sort of mixed messaging that I'll know better for my adult child with a disability, and I'll be able to promote their independence, but that's for me to decide and not them to decide. And there's the well-intentioned conflict at that moment in time. If you're representing a petitioner or if a family comes to you for this, these are questions that are good to ask about what is driving this process, because well-intentioned parents who feel they need it for the bureaucracy really don't need it for the actual support of their adult child. And it's murky. And it's getting a little bit better, but I think the panelists have wisely pointed out that there are many questions that can be asked. This is one of the difficult areas of practice for lawyers because we're often giving non-legal advice. This isn't taxes. So you walk a fine line between advocating for your client in a way that gives a broad array of information so they can make a choice that's in their best interest while also giving appropriate legal information. But I encourage you to consider the fact that as we evolve as a society and the paradigm of service delivery, so should the legal advice you give to people, because the plenary blunt force power of 17A. Now, a couple of quick comments about that. One, many guardians who are 17A guardians are well-intentioned, have very little control, and do not substitute their judgment for the person that they are guardian for. And it is, as Kate mentioned, there are bad apples. There are many parents who still view their adult children as children, even though, remember that 90% in the mild range, who I support, who clearly manifest day in and day out their ability to function quite well, to manage their affairs, make their own decisions, and essentially impart meaning in their life on their terms without the need for a guardian. And parents, of course, are substituting their judgment because there's value decisions being made by the child, how they express themselves sexually, or how they express themselves spiritually, or the decisions should they make. If a parent of a person who didn't have an intellectual challenge could get guardianship over their kids who are eating their chips and drinking their beer at 28 in their basement, they would exercise it to get them out, to get them get a job. So the well-intention of parents at this difficult time is in the mix. And of course, should be possibly discussed in an educational platform. And I know we'll cover some of the alternatives, but I just wanted to recognize not from my legal hat, but from the provider hat, that the array and the spectrum of challenges presented by this are immense. And we do see, because guardianship was gained over so many people that we support now that really don't need it, we do see a turning of the tide with restoration, and a shift of the use of the 17A to a more support model and less control model. So I'm very grateful to be part of the panel. I look forward to the next series of questions from Lawrence.
Thank you, Chris. Okay, fascinating discussion pieces are coming up here, and we will. Okay.
Before we move on to the next question, I would like to share the first CLE code word for those of you who are seeking CLE credit. This code word will need to be added to your affidavit of attendance. So the first code word is advocate. You might also, in a different meaning, say advocate. That word is advocate, ADVOCATE. Those of you who are on Zoom should see it on your screen. Again, that CLE code word is advocate. Thank you.
Thank you. I take a lot of interest in the code words that the law school has been picking over the last 4 of these programs. They have character. Okay, you know, in listening to all of this, I'd like to kind of pick up on something that came up consistently in terms of the next question that I'll present to all of you. And this is the issue of whether or not in the petitioning for guardianship, under whatever it is that comes out eventually, there should be either an allegation that certain other forms of assistance short of guardianship, short of plenary guardianship, were tried and failed, or are just inappropriate, and the reasons why they're inappropriate. And that's different, whether you try and fail or you are alleging they're inappropriate. And this ties in a little bit, perhaps, when people are addressing this issue to something Chris just talked about, and I think 1 or 2 others, and that is, at the point of aging out of the educational system, parents are advised guardianship. They're not advised of anything else. And that's kind of like one of the checkoffs. And that's done for reasons that both are historically ignorance, but it's also done because the agencies that are providing services, a variety of kinds of services, may be looking for that, may be looking for guardianship. So when we start looking at alternatives to guardianship and limited guardianship, and what should the petition include in terms of whether or not that has been tried or whether or not that allegedly is no good, one of those limitations in the appointment process at the end, not just in the petition, but in the end, when the order is issued, and if it's a limited guardianship, should we pay particular attention to the issue of a limited time guardianship? It's been raised, for example, and I'll throw this for discussion, that if an individual, if a guardianship is applied for an individual between the ages of, let's say, 18 or 17 and 22, the guardianship should have to automatically be reviewed when the person reaches 25 and has gone through that kind of transition period that all of our kids have gone through, whether they are disabled in any way or not, at that age group. So I'd like to ask those of you who, and in your response, also, if you have familiarity with one of the proposals that I mentioned earlier on, the Law Revision Commission proposal or the circuit judge's proposal, that you look at those proposals, or the Olmsted proposal, the Olmsted cabinet proposal, you look at that and in your answer kind of throw that in so people know that those are there, that those proposals and why. So I throw that out. As I said, I'm not going to call on people now. I'm going to ask you to go ahead. Anybody, who's first?
So I'll start it off by saying that certainly the Law Revision Commission proposal and a number of the other proposals do indicate that the petition must allege that all less restrictive alternatives to guardianship have been considered and allege why they may not be satisfactory. I think over the conversations that a number of us have had, it presents a difficulty of timing if, for example, the petition is sought in the transition process, so the person is 17 or 18 years old, there may not have been an opportunity, time, or educational process to understand what those alternatives are and how they might work. So I think, I'm thinking personally, and I don't think it's in any of the proposals, maybe some sort of time-limited guardianship, which would give families an opportunity to explore those options. I think it's come up in the supported decision-making arena, because the supported decision-making reports indicate that these arrangements take a fairly substantial number of months to complete. The process of facilitating the agreement can occur between 9 and 18 months. And if the family is of the view that the adult child is not going to be able to make decisions for themselves, at least during the transition period, say 18 to 22 to 26, that a guardianship would be appropriate to make those decisions while there is an examination of these alternatives, including supported decision-making. So I'll just say that, see what people think.
Can I respond to that?
Absolutely.
I think I agree with Rosemary, and this is something that in the various revision efforts that I've been involved in over the years, a key element that came up was the lack of or the need for education so that people really understood their options. We talked about in one version sort of a box check to say that, yes, I have assessed, and as you said, Larry, determined that these aren't going to work for us, but there needed to be some sort of pamphlet or something that folks could at least be handed when they were reviewing the petition. And there's some really good resources on the OCA website around how to prepare the 17A petition. That would be a good place for it. That I think is key. But I think another thing that we haven't discussed yet that I wanted to make sure I mentioned, kind of phrasing it as that the alternatives have been determined like inappropriate or failed, right? That they didn't work. We have seen a lot of cases in which the individual that we are looking to support wants the guardianship. And so I think there needs to be room for that as well, where, you know, we've had guardianships that were time limited, and then we went back to the court and the individual that we supported wants the guardianship to continue. So I just think there needs to be room for that as well.
And can I say, and that's, you know, one of the two paradigms for an 81 is consent, and having a whatever guardianship structure you have be one of the options be having it on consent, as long as the consent can be revoked, which we see sometimes in 81. I think I agree with you, Kate. That's something that should be provided for. And you use the words education, the word. I'm not one who advocates for mandating other approaches be tried and failed first, but the Richmond County, which is Staten Island surrogate, for instance, has a program where they require folks who want to come in and apply for 17A to now view some video programs that they have put together on the alternatives to guardianship. And in my practice, I talk to people, you know, everybody who comes in front of me gets my question: do they know what supported decision-making is? Have they, and in these discussions, what I find is that most of the time, probably a large majority of the time, people don't know it as a legal concept, but they understand it as a way to work with their child to navigate life. And that it is the intention of most parents as guardians that they will engage with their child in a supportive way to help them. As you say, Kate, they have to get through life and they have to accomplish things. And so you are supporting their rights by giving them the tools to do that. So I think people do need to be educated. And I think having at least, you know, I think a mandatory training program as an alternative to, as a precursor to filing a 17A is not a bad option. So I do think that's, and we have reporting requirements in 81s. We have, in my court, we have reporting requirements only for property 17As. Some of my colleagues do require reporting of person 17As. We periodically find problems from these reports, but we typically don't find those problems until too much time has gone by. And so one of the things that my colleagues who are issuing these decisions on limiting 17As are doing, and I think it's an excellent idea, is providing specifically for some review period, you know, come back in 2 years. You know, and my predecessor used to sometimes condition an order on a temporary situation that could be reviewed. People never think to come back unless you make it mandatory. So when I do things like that, I say, okay, here's the date, be it 6 months or 2 years, we're going to come back on this date so everybody knows. So.
Judge, could I ask you, when you say come back, let's say in 2 years, let's pick a number. Do you have a system to track that, and in 2 years send out a memo saying where are you? We will do a scheduling order, and then I don't calendar it. I'll be honest with you. My chief clerk or my law clerk and secretary, we calendar them, and the time will come when
I'm not going to be there for the review, but we'll still schedule them.
I asked that question only because in our experience, we've seen situations where we've tried to find out how many guardianships are actually existent in the state. And what's the status? And is the guardian still alive? And is the ward still alive? And half the time we historically, when we've been doing these studies on guardianship, we've had a hard time finding that kind of information.
Yep.
So
Yep.
that's the kind of basis why I asked that question.
I agree.
I'm sorry, Larry, were you?
No, go right ahead.
So, I mean, I think if you're looking for a yes or no answer to the question on whether there should be both, I think you asked two questions, one about the limitations and one about requirements for alternatives, I would say yes to both of those things. I mean, from my perspective, talking about the alternatives, and if you look at the memorandum that Rosemary Bailey prepared, which I think is part of the materials, it actually goes through a lot of the comparisons of the different options better than I think, a lot of us could sort of, rattle these off here. But in talking about alternatives, I understand, from a parent's perspective or an agency perspective or a court perspective, you don't want to necessarily have something fail first before you look at a guardianship, but at least a consideration of why least restrictive alternatives would not work, for example. And sometimes that might include, well, we tried this, but it wasn't successful for whatever reason. And least restrictive alternatives, and I think we've all touched on this a little bit, could take many forms, from formal supported decision making, and there's an article or two in the materials about that. That's Article 82 of the Mental Hygiene Law, but also the sort of informal support may be coupled with having an individual sign a HIPAA release so that they can talk to the doctor when someone has medical issues, or being able to allowing them to participate in life plan meetings or in other types of meetings involving care, or a healthcare proxy, so that if there are issues in the future or complicated medical issues for which a person lacks the capacity to make a decision, but has the capacity to sign a healthcare proxy, that their family member or the individual that they've picked can make decisions, and certainly powers of attorney in certain areas. But there's also, I think, a use for the limited guardianships. I mean, we've been involved with guardianships that were sort of single transaction, setting up supplemental needs trusts. I'm sure that Lisa Friedman in her practice, if you're doing, future planning, estate planning, that, probably comes up. Maybe there's a piece of property that needs to be disposed of. Maybe there's something currently going on that really can be addressed just by one or two powers in a guardianship, but doesn't need to be sort of a plenary or a long-acting guardianship. 17A doesn't lend itself to that, although many judges are willing to do that. Article 81 certainly is set up that way, and there's a number of proposals here in the memorandum, whether it's the LRC or the OCA proposal or the Olmsted Working Group proposal, that talk about limitations, not only in terms of powers, but also, again, in terms of time, as we talked about with Judge Guy. Judge Guy had mentioned at the end of his comments about, a limited time guardianship. We've had many, many guardianships, 17As, but mostly 81s, where we've asked either for it to be a fixed period of time, like the guardianship is going to expire unless somebody does something to ask that it be extended. Maybe it's because someone's had an accident, or maybe because there are certain issues that need to be addressed, disposing of property, for example. But we've also had a lot of cases that we've wanted reviewed. And some of it is sort of the young adult situation, maybe that Chris Lyons referred to, sort of looking at that period where someone is aging out of school, and it's not really clear maybe how independent they're going to be able to be, how much assistance they need. I mean, I've had clients who lived at home with family, and it wasn't until they were out in the adult community, till maybe they were in a day program for people who are in the OPWD system, that they learned independent skills, that someone was able to teach them how to ride a bus, how to open a bank account. And sometimes it's a really wait and see, can someone learn the skills to be independent where maybe they don't need the formal safety net of guardianship, or maybe there's something event that has happened, such as a stroke or a particular medical issues that someone may, come out on the other side of that and be able to make their own decisions. The problem I think that we've had with these limited guardianships, whether it's the powers or whether it's the time, is how then we get back to follow-up. And I do know that some of the proposals in here talk about, sort of permanent sense of follow-up with guardianships. And I'm not talking about reporting. I'm talking about, I think there are some proposals that talk about appointing, MHLS to review at a fixed period of time. It looked like a sort of full employment act for MHLS attorneys. It would require a lot of us. But part of the problem we've had is, how do you calendar something for review? So for example, I recently had a guardianship with a very impaired young child, and they're not 18 yet, but they did use guardianship as a vehicle for decision making. They anticipate it will go way into the future, but we don't really know if this person is going to make gains. They weren't born impaired. They had a horrible accident, and it's not really clear what kind of gains they might make. So we decided it should be reviewable in 10 years. Who's going to make sure it's reviewable in 10 years? I mean, I might be retired. I might not be. I suppose I could put it on the calendar in the office. The court wasn't necessarily inclined to say, I'm going to contact the parties in 10 years. It was the parties should contact the court in 10 years. So that often puts the burden on, in this case, the petitioner was not the guardian. It was a corporate petitioner, and it's a family member who's the guardian. So the burden is on who to make sure that it gets back into court. And we've had other examples like that, where we had a guardianship that would to be, reviewable in a couple of years. I can't locate my former client who is the subject of the guardianship. We've usually, I think the burden has been put on the attorney or the subject of the guardianship, or maybe the guardian who might not want to contact the court to review the guardianship. Because I think the courts probably feel that they don't really have the mechanism. If it's a year, you can calendar it, you can send out a letter. But when you're talking about 3 years, 5 years, or in my extreme example, 10 years, I think it's difficult. I was interested in the proposals for limited scope guardianship and the follow-up that would be required, because I do think that these are things that we use to make things least restrictive, and also to come up with a viable plan to maybe get everybody on board and have something not be contested. But I do worry that when you craft these resolutions, sometimes you get it all on paper, you get a nice order, the judge signs it, and I put my file away, and then you wonder, well, what's going to happen? Who's gonna, what's going to be the follow-up? So, and I would encourage everyone to take a look at Rosemary Bailey's memorandum. It's really, terrific. And I think it kind of addresses a number of these issues. The last thing I'll say, and then I'll turn it over to someone else, about a time limit. Another reason why you might want to have a reviewable guardianship after a short period of time is you may have an issue where there's some conflict between the proposed guardian and the subject of the guardianship. And so sometimes you need a little bit of time to see if whether they can work together, or whether the co-guardians can work together, especially if you have a situation where maybe it's parents who are no longer together, or siblings who are guardian for a family member. So there are, I think, lots of reasons for review and for time-limited nature, and also for narrowly tailoring. How we structure that in proposed legislation, I know they're going to talk about some of this, I think, next week or later on today. I think there has been a lot of work to sort of come up with some ideas. There's also some other materials that I think Rosemary put together. that talk about some of those issues, but I think they're all good to think about, these kind of limitations, how we get them into legislation and how we work them into practice. I think that's the open question.
That's a good question that you raised, is what happened, and Lisa, maybe you want to respond to this, Lisa Friedman. Well, yeah. That if you're looking at something that's more than a year, let's say, how do you know, like it's been proposed, for example, that a time limited guardianship, either any guardianship under, you know, when the individual is under, let's say 20, should automatically have to be reviewed at 26. How do you do that? You could calendar it, but you don't know where you send out a letter, you don't even know where the people are living in anymore. They've moved. How do you enforce that? Anyway, Lisa, I'm sorry.
In terms of time limited guardianships, particularly where you have very young people that are the subject of the guardianship proceedings, they're not out of school yet. We don't know where they're going to go. And I think it's important for, in those instances, that you come back, you know, well, I'll pick 26 because 26 is a cutoff for a number of different laws these days, from a property point of view and otherwise, where someone has to come back and confirm that the guardianship is needed. There was a decision that I saw today that was decided yesterday in New York County, where they had a 1-year time limit, and you know, the guardianship was going to end after a year unless somebody comes back to continue it. And the court basically reported that the family found alternatives, or the petitioner found alternatives, and the guardianship remains terminated. But in the case of very young people, you know, a lot of things can happen between the age of 17 and the age of 26, 27, even up to age 30, where you're dealing with a completely different person. And some of the cases on Rosemary's list report that as well. And I just think it's important. We have to figure out the mechanism to make sure people come back. But for that population, that group of people, they may not need the guardianship anymore, and the individual may not have the capability of going after, in many instances, mom and dad. And coming back into court and having it reviewed may be to everybody's benefit.
Mm.
And the individual may not need protection anymore, you know, which was the reason why parents went in to apply for guardianship initially. And times change, so who knows what it'll be like 10 years from now. So
That also, that time limited addresses partially the idea of the difficulties with restoration and the burden of proof that, at least in those periods of time, it would be the petitioner who would say it has to continue, as opposed to the respondent having to make a case for why they don't need it anymore. Could I ask a question, Larry?
Absolutely.
Judge Judge Guy, you had mentioned in your particular status, and those of many other judges upstate, that you actually wear two hats, the hat of the Supreme Court judge as well as the surrogates court, and hence you have covered both types of cases. You alluded to a dedicated guardianship part. Leaving aside probably all the political and economic reasons why that might not work, well, could you talk a little bit more about the idea of dedicated guardianship part and what you see as maybe the advantages or disadvantages of it?
What you mean in the surrogates court, in the larger courts, they have a dedicated guardianship part, which does the administration. You still funnel up to one judge, although in some of those courts, I know that the members of the law staff of the surrogate will actually do some of that 17 hearing work. But I think it's very effective to have on the Supreme Court side, when you're talking about 81s, I think it's very effective to have one or maybe just a small number of Supreme Court judges doing 81s. I can give you an excellent example that is before me right now, where there was a 17A put in place for a young person who was injured in birth. And then there was a medical malpractice case. In the context of the Supreme Court settlement of that case, her parents were put in as custodians. It's that old. And ultimately, there was an order issued that replaced the 17A guardianship with just the, now this was in 03, an Article 81 guardianship. Between, I think, 86 or 7 when the case was settled and 03, there were probably 6 different judges that had that case. And what each of them did was they approved a different request by the guardians to take substantial sums of money out of the minors' funds to do various things to their house or buy them various things. And so there was a complete lack of continuity and oversight of that case. Now it's in front of me because the guardians stopped doing financial reports. And again, it went too long from the time the financial report stopped till it got in front of me. I have 2 or 3 of these cases percolating around where huge amounts of money have been misappropriated. They are far and away the exception and not the rule. But when you have these cases, if you're going to keep on top of them, you need them in at least a consistent chamber with a consistent staff, like in the surrogates court, rather than, you know, just on the wheel in Supreme Court and getting bounced around. There, if you're going to monitor a case, you have to keep it consistent on the court side.
Well, if I could just hog this for one more moment. I'm hearing you say that the surrogates court offers an ideal opportunity for a dedicated, by virtue of the fact that it's mostly just one surrogate in a county. How about giving the surrogates court Article 81 jurisdiction beyond what they currently have, which is limited to cases with estates involving someone alleged to be incapacitated?
So my understanding is that the reason that that was not done in the first place is because the volume that it would have imposed on the downstate surrogates, which is a realistic thing. And you know, my personal perspective is having multiple surrogates in a county is not a good thing. And part of this is the issue of who runs our courts. Does the Office of Court Administration run our courts, or do the judges? That's a discussion I don't want to get into today. And the OCA certainly doesn't want me to get into that discussion today. But that is, I think, the delicate issue. The surrogates are willing to take on more responsibility, like Article 81, but we feel very strongly that that's something that we need to manage, not somebody else.
Thank you.
I think,
Sure.
you know, I think it brings up other issues in terms of in which court the guardianships are in, because, you know, the Surrogate Court Procedure Act follows the procedures that are used in surrogates court, and Article 81 follows the procedures that are used in Supreme Court. So in turn, and I guess the county court as well can have jurisdiction, but in terms of procedures for filing motions and responding to motions, and surrogates court has always, in my impression, been designed to be extremely user-friendly. People come in to deal with, you know, estate matters without having attorneys. The clerks are used to providing, well, not legal advice on which form, information, I would say, is probably more accurate, which forms to use, what they need to complete. And whereas things that are filed in court to be heard in county or Supreme Court are really a whole different animal. And maybe that's a whole other issue about legislative reform. But there are surrogates who, you know, like Judge Guy, are also acting supremes. And we have, in a couple of occasions where we've had a 17A, we have filed a motion for a 17A to be converted into an 81. Now, whether you want to say the 17A was in a sense dismissed by us filing and asking, you know, filing a petition for it to be treated like an 81. But in the cases that I'm thinking of where we've done that, it happened to be a surrogate who could also act as an acting supreme So it wasn't our desire to try to get it away from a particular judge or court. It was more of, we thought that it was the wrong vehicle for various reasons. And some of the judges are very willing, to do that. And we don't really have a guardianship part up in the 3rd Judicial District in terms of a dedicated surrogate, for example. But Judge Morgan does most of the guardianships in the 3rd Judicial District. He is a surrogate. He does it as an acting supreme. So he does, I think there's 2 counties he doesn't dip into, probably because of the distance, but he does, he basically is the guardianship judge for the 3rd Judicial District. It is useful in that, we have like a regular, routine and a process. And we know there's some predictability as a litigant who appears before him. We know there's a bit of predictability on how he handles the matters. I know they've tried that with other upstate counties, but it was the distance, I think, that made it unworkable more than I think the volume.
And I will say Nassau and Suffolk both have guardianship parts, and they have a presiding judge of the guardianship, and those folks kind of coordinate the cases among a small group of Supremes, because again, they have the large population down in those counties. So, and
let me say that we have, oops.
Hello, sorry to interrupt again. I have the second CLE code word for those of you who are seeking CLE credit today. If you're on Zoom, you should see it on your screen. That word is statute. That is spelled STATUTE. Again, your CLE code word is statute. Thank you.
I think that this discussion flows into one of the other questions I was going to ask, so I'm going to skip over to that one, and that is the issue of accountability, because accountability of almost any kind implies that the court retains some kind of oversight, whatever that might be, and however that might happen. But I'd like to hear some opinions on whether or not they should, as we know, like guardianship of the property under 17, and that is, there is a report, but not any kind of reporting required of guardianship of the person. 81 has the reporting. I don't know how good that is. We could talk about that. But what are people's ideas or senses about having some kind of oversight of, and perhaps building into that some kind of available assistance to the guardians to accomplish their tasks and what they're doing on some kind of periodic basis? Who should do that? Who should do the oversight? Who should keep the court abreast of what's happening, if they should? And what kind of burden does that place on the guardian?
I'll speak briefly from the provider standpoint on that, Larry, because
Good.
we are the de facto conduit of accountability for people we support who have guardians. Because, and this was mentioned about an hour ago, about some people for whom guardianship is sought consent to same and wanted. But I know Lisa will speak to this, and other practitioners, that particularly again with the aging out population, they don't want to upset their parents who are seeking guardianship. And so they may voice to everyone but their parents that they don't want a guardian. They want to make their own decisions. And then when the hearing or the appearance comes up, they're like, yeah, I want my mom and dad to do that because they're asking to do it. I've seen that happen time and time again, which goes again that to the accountability, because as this process goes on, who is actually making sure that there's some review process so that the least restrictive situation is extant as that person grows, imparts meaning in their life, gets to be able to experience life, has the natural consequences of their choices, has the dignity of risk, learns from their failures, on and on and on. This is a very organic process that it has captured at one moment in time and then has no. So from a not a bureaucratic or resource or paperwork standpoint, accountability is key. And as a provider of adult people who have guardians, we end up being the de facto person. We can either try to persuade the guardian to be a little bit more supportive and a little less controlling, but there is no formal challenge. I have gone into court to suspend guardian rights where I see there's a bad situation, and I've helped people restore their rights. But just from a pure moral obligation to the people who now have a 17A hanging over their head. Accountability in some form would at least systematize a review of the process for those who, not wanting to upset the guardian, really do want to have it limited or removed.
Kate, NYSARC has a very robust guardianship program, accountability program. Do you want to talk a little bit about that? Because I have a question for both of you, but I was hoping maybe Kate, you could talk a little bit about it first.
Sure. So the ARC New York Guardianship Program is it is of our own making, right? So it's what processes are required. There's an application if a person's interested in having us act in any capacity, either as a primary or standby or alternate guardian. That's pretty comprehensive, asking a lot of questions. And then each year, each of the individuals that are in our guardianship program we're getting an annual report that's sent to the ARC New York State Office, which is where I work. It's reviewed and questions asked. And the structure that we use actually are voluntary committees that are placed at our provider locations across the state that are made up mostly of volunteers, non-board members, and some board members of our individual chapters, as we call them. And they're the ones who actually make the decisions for the individuals and help support them. So there is a substantial report that's done. There's follow-up questions asked by our office, by the local chapters. So we're pretty comfortable with that. But I recall in one legislative session, I think the issue of reporting is potentially what ultimately blew up the passage of that bill that particular year. And I'll just share why that is. Just from a parent's perspective, from things that I heard from families in our organization and families outside of our organization, which is, again, this is a job, so to speak, or a function that they've been performing for years. And this is not, weighing in on whether this is appropriate, whether this is right or wrong, just sharing what the perspective is that, this is something they've been doing. And, to have to kind of report back to the court about how they're taking care of their loved one and providing support to them is troublesome to them in many ways. And I think to answer a question that actually is in the chat from someone about how do you deal with guardianships that are already existing, to the extent that we potentially don't have good data about the whereabouts, or the current address of folks, to impose a reporting requirement on existing guardianships could be problematic. And then what do you do if you don't receive the report? Does the court have the resources? And that was always the issue, to follow up with individuals. What are the consequences of that? And if the court gets them, are they reading them? Are they following up? It becomes a challenge.
So Larry, you and I have talked about this many times because of other things that Kate and Chris have mentioned. We heard the same concerns expressed by parents who guardians. We've heard about the courts, the lack of resources available to the court to carry out that piece of the process. So Larry had a couple of ideas about how.
I'm not a member of the panel. I get to ask the questions, not answer.
Oh, you don't get to talk? Well, I guess Larry.
No, I would ask the question. I would ask the question, and getting us a little closer to it, is that when we're using the word accountability as well as reporting here, and that's an important distinction. And using it as a quality issue, not picking on anybody issue. Is a report from a guardian, even if it is done, and even if we got it into the statute, even if parents did it, to the court, mean anything? Because they're not going to say, I didn't do anything this time. I never saw Johnny. And the court's going to put it in a file, and is the court clerk capable? It's not a financial document now. It's not 2 and 2 equals 4. Where'd the 5 go? It's a human interest issue. It's what services activated, what services were done, was it appropriate for this person, what that the guardian signed for, did the guard, and so as a support to the guardian, the question is, are they getting the support they need during the course of this last, let's say, 2-year reporting period? Did they get the support they need to perform a quality role as a guardian? So the issue that I think you're raising, Rosemary, is it possible that maybe the quote accountability or reporting should not be the responsibility of the guardian or the court to follow up on it automatically, but, or a court clerk to read. But should it be somehow, and again, there's a money issue here, be a contract with some kind of social service, or maybe something like NYSARD
Well,
to do visits yearly or bi-yearly and find out what's happening on this guardianship. And I throw that out for discussion.
I think if I can, I think if and I listened with interest to the point that that Kate had made about people who believe they're doing a good job, especially if family member don't feel like maybe they should have the intrusion of people checking up on them. So I can only imagine if it was some agency that had to check up on how they were doing, how that might fly. But I think that, if we look at, let's look at what's been tried in Article 81. And I will say that there are some surrogates, including Judge Pettit in Albany, who does request some reporting, some follow-up, even if it's not just a strictly property guardian. I hope that wasn't a bad thing I did by outing her, but that's
No, I think it's known.
But let's take a look at Article 81. And there are the account examiners in every single county. Some of them have a little more of a robust follow-up than others. Some of them, if you're not following your reports, they're very quick to request a compliance conference with the court, or after writing a couple of letters and trying to find out what the issue is. Some of them are looking to see if there's actually looking at the numbers. Is money missing? Do the numbers add up? I don't know that they're really in terms of the, let's say, personal guardian powers, really judging what the quality of the involvement is. So are they looking at the form to see if someone says that they visited 4 times a year, and now with COVID, now people are saying, video visits are sometimes acceptable. Are they just attaching a service plan from a nursing home or a life plan from an OPWDD agency instead of sort of answering the questions? I don't know that most accounts examiners feel that they have the information they need to sort of evaluate all of this. That being said, I have been on some cases where some account examiners have noticed concerns that were other than financial and have raised them with courts or with my office, to good effect, to addressing things. I know that some people do struggle even with the Article 81 reports, which, although they don't seem that daunting, sometimes there's some, confusion, and what do we fill out and what don't we fill out? And I'm not sure what the questions are asking. I think there could be a simplification of those types of reports. And I think that's what some of the surrogates are looking at. I think that you should be able to do a report online instead of just, filling out this paperwork. And if it's not e-filed, or if you're not an attorney, you don't have access to e-filing, you're mailing what could be a significant stack of papers, to a number of different parties in the state and filing with the clerk. So I think, there are ways that you could do reporting and you could simplify it. In an ideal world, there would be enough funding, there would be enough people where you could have meaningful review. One of my colleagues who's watching this right now said, what about a yearly conference, right? So, a yearly conference, I think, is a great idea. I'm sure that Judge Guy and his fellow judges would say, it's a resource issue. We don't have the time, then we'd have to send out a letter. Then we'd have to, what if they don't show up? There's staff issues involved. There's, where are the parties? Certainly we can do more by video, but I think it's a great idea, whether it's practical, whether it would ever find its way into legislation, probably not. But I do think you could take a look at the 81 report, see how you could really maybe make it a more meaningful report and have something like that included with any legislation. And I do think there are some, discussions of reporting. But again, I agree, there's reporting and then there's meaningful follow-up. And
Right.
And I don't know that that really any of the proposals talk about ways to follow up that don't require expending resources. I mentioned this earlier on, where it talks about in one of the proposals that mental hygiene legal service should have to follow up. I think it was, which was that that they would be appointed and they would have to follow up after a period of time. Whether or not that's something that, is realistic. I think a lot of these issues come down to resources.
Right, I think that might have been the Law Revision Commission proposal to have the mental hygiene legal service. The assumption being that they would be representing the individual in the proceeding, and then they would follow up in a period of time thereafter. I'll just raise one other possibility that I brought up to Larry and Chris in preparation of this meeting, the perennial life plan that individual, Chris is already laughing. But one of the, in other projects that I've worked on, the effort has been not to duplicate people's efforts, right? And so we know that there's a certain percentage of people who are involved with people who develop and help work with them on a life plan that's reviewed and updated every year. You're laughing, Chris, already. So I'll let you talk about the life plan and what role, if any, that might play in sort of an ongoing assessment of the guardianship.
I'll say something.
Right, I know you said it before.
All right, so, there's no reporting. Nobody knows in surrogate's court, none of the clerks, they don't know if people are alive. So if you have a guardian, if you're sending in a life plan, at least you know the individual's still alive and the guardians are still alive. There was the Kings County decision where nobody applied to confirm a standby guardianship for 20 years. So it was dismissed, but nobody knows, all those file drawers filled full of decrees. You don't know if anybody's still alive.
Well, I think Judge Guy knows because he's in.
Well, but he has a smaller county and,
Right.
That, absolutely,
Right.
absolutely.
But, there's no way of knowing if some of these people are alive or their parents are alive who were the guardians. They may be in nursing homes themselves.
But isn't that a real constitutional problem, that there is no oversight? I mean, how it's resolved is obviously something we need to keep talking about, but there is a constitutional infirmity that we have guardians appointed for individuals and there's no follow-up of what is going on with the person, well-intentioned or not.
At the risk of throwing a whatever in here, I was gonna say red herring, but it's not, that's not the word I want. Let me read from a decision by Judge Glenn in the Mark C.H. case. This was 2010, and her conclusion in this case. Quote, as a matter of fundamental due process, the state may not impose the extensive loss of personal liberty inherent in the guardianship process without some guarantee that the person or persons for whom it has granted persons to whom it has granted guardianship of the person continues to act in her ward's best interest, and that the ward is at the very least no worse off than before guardianship was awarded. And then it goes on, utilizing that what process is due analysis it is clear that the court granting guardianship of a mentally retarded or developmentally disabled must require periodic reporting and review or monitoring. A guardian of the property, and then it goes on to guardian of the property. Is that what you're saying?
Well, that certainly she makes the argument there for why she did order that there be an accounting. So Judge Guy, you had mentioned that, you have accounting as the statute requires when there is financial, when there are assets, property. Could you explain how your clerks go about that? Do they contact the individual?
We have a database, from our system, we can print out the names and addresses. We do form letters with the reporting form. And in my county, this is time consuming and expensive. Imagine what it would be in, any other county in the many other counties in the state. And then when people don't respond, we cite them. When they don't show up for the citation, we will expand the citation to include, often we'll appoint mental hygiene. And, but I have talked to my chief clerk about how Judge Pettit and others are requiring that for person-only guardianships as well.
Mhm.
And we are strained to keep on top of the ones we do ask for. And so I have not pushed to impose person-only guardian reporting. I figured I'd let the statute do that for me when it gets revised.
If it gets.
Yeah, I'm hopeful that it will.
Yeah.
And Kate, from your perspective, do parents mind the reporting? I mean, do you guys get a lot of pushback?
Well, in our case, if we're doing the reporting, it's because there is no actively involved family, right? And so we're the ones doing the reporting, and oftentimes there's a service provider like Chris who helps you kind of understand the environment. And there's a lot of regulation and oversight within the service provision environment already. And so it makes it a little bit easier to do that. So, you know, we're standby guardian for many families who do serve as the primary. But again, I just know that that's the perspective of some families when this issue originally came up. And it was what I mentioned before, but it was also the concept of being asked to do the report for the sake of doing it, and understanding that it was admitted that no one was going to have the resources to really do it. I think that has to be better vetted, which is what is the real goal of what is oversight, right? And what is the goal of it? What's the outcome we want? Do we want to know how many visits someone made, or do we want to know, is this guardianship improving the quality of this person's life?
Right.
What type of decisions are being made? How are they making those decisions? And I realize that that's a more detailed and difficult thing to kind of elicit from folks. But to me, that really is what matters. Is this still wanted? Is this helping? You know, not some of the other stuff, but that also is harder to obtain.
And that's the other thing my chief clerk says to me is how will she know what she's looking at from a person? And honestly, every court examiner I have in my district on an 81, same issue. They're all lawyers. They don't, except in glaring cases, they don't have the training or the expertise to pick up whether it's effective or ineffective from what they're seeing.
Right.
So I think that means, and this is not on our list, but that raises a question of training. Should there be training, maybe not families, but for the standbys who haven't been eating and sleeping this stuff all along? And I'll duck now.
Well, no, but that falls into the category of what is the standby who may not have been involved.
Right.
What are they going to learn when there's no report, when there's nothing, when there's no information?
Right. But
where are they going to get it? The life plan.
But the training and the accountability goes hand in hand if it's done right.
Right.
I think in terms of I would come back to, if I can here, to what Kate said. I think in terms of the reporting or the accountability end of it, there's no point in enforcing something like that unless it's going to be reviewed by somebody who is appropriate to review it. Now, Kate, in the NYSARC cases, or the ARC New York cases, I go too far back to the original names. The reports that the chapter send up regularly, yearly, is it, on what's happened in the last year in Johnny's life?
Right.
Are they reviewed by just the staff in Erica's office, in the guardianship office, or are they reviewed by volunteers in Albany? I mean, not the ones who helped at my chapter, what was my chapter, but when they were sent up to you guys?
I think I'd have to check with Erica what the latest procedure, because the director of our guardianship program who's been with us for a while. I think it's essentially staff, but there is a summary of the sort of current status of the folks that are served in the program that's done on an annual basis in an aggregate form. But I think it's a double report, because the chapter guardianship committees, who again are the ones that actually know the individuals, work with them every day. Many have done the committee for 15, 20, 25 years. They're the ones preparing those reports, right, and reviewing them. So it's sort of a double review of the status. And it does ask for a lot of the information that we've talked about here, number of visits. There's also minutes from committee meetings that are sent to our office as well, that we can see kind of what type of decisions are made, how things are being discussed, how often folks are being visited, where they're living, any changes that we should know about. So it's pretty robust, but I kind of wanted to address, there is a question in the chat about like, how do you get a guardian if you don't know somebody that's willing to act as one? And I think that kind of dovetails to this conversation, which is it's pretty hard to find one. There's been a few times where MHLS, for example, has identified, hey, there's this person that's come before us, they really need somebody, or they've got somebody and maybe they're not the right one. Can you do it? And I think there are very few organizations out there, right, or that are able to do it. And the more onerous, I think the less folks there will be that can provide this service. So I just put that out there as well and try to answer at least one of the questions that I see in the chat.
So there's another question which relates to that, which is, has there been consideration of reimbursing or compensating a guardian for additional responsibilities such as providing reports?
I mean, there are, there is a mechanism in Article 81 for certain, fees and Surrogates Court Procedure Act has a way to compensate people who, let's say, work to monitor an estate. I think it's interesting how, it's not really a direct answer to the question, but I think it's interesting how we've gone from where we started at the very beginning with Larry's discussion about, how we got to today in terms of looking at what are the civil rights challenges for people who have developmental disabilities where there's a guardianship system. And then we talked about, a number of those issues, and then started to talk about how inconvenient it is for people to do reporting and how much might be a burden on the family or resources burden on the court. And I don't want us to lose sight of the fact that, again, we're talking about an imposition on somebody's life. And when you have, whether it's a corporate guardian, and I know that Center for Disability Services, they do something, very similar with their corporate guardianship. And, Kate has described, they do a lot of record keeping, they do reports because I've seen them. I don't think that it should be considered a burden on family members who are guardians to do some reporting. They stood up in court, or at least alleged in their papers, that they had the best interest in mind for the person they want to be guardian for, that they were willing and able and suitable to be guardians. They sign an oath and designation. And I think it's really just part of a responsibility. Now, that being said, I talked about how maybe there's a way to streamline it or make it more meaningful. But it's a little frustrating when we get sort of lost in, this is inconvenient and this is a resource problem. Because if someone is taking on the duties of being a guardian, if they're saying I'm willing to do this, should filling out some paperwork be really something that is somehow like, that's too much, I've gone to court, I've done everything I need to do, I'm willing to do anything for the person I'm guardian for, except fill out paperwork. And I hope that's sort of not where we end up today, that filling out paperwork is just, a bridge too far in terms of someone who is seeking to make decisions for another individual.
I hope we end today returning to inspiring people to educate. The judge mentioned this. There are videos, there are OCA documents, there's all kinds of resources that you can refer potential petitioners to have a robust conversation about alternatives to guardianship before they make the leap. And lawyers, it should behoove lawyers to get the best outcome for their clients to mention those tools so that a thoughtful process occurs before any of this happens, because there are so many. We didn't really talk much about supported decision-making as an option, but it's a very viable option that now is legislatively created that I hope all practitioners will consider. So as we end today, I just want to inspire people up front, look at alternatives, and every situation should be customized for what's in the best interest of the individual.
Well, part 2 of this panel will continue tomorrow. This has been, I don't know if anybody wants to say parting words at the very end, but we've now reached our limit
I'll
here.
just say thank you to Chris for his words of inspiration. Thank you, Larry, for leading our discussion, and thank you to all of our panelists for an absolutely fascinating and important conversation about these really critical issues.
And I would like to thank all the panelists and the law school for sponsoring this and making it possible, and all the panelists. This was a excellent conversation.
And please join us again on April 13th.
Absolutely.
Thank you very much. Thanks, guys.
Bye.
Bye, everybody. Thank you.
Thank you all for joining us this afternoon. We sent the CLE materials by email, but if you did not receive them, please contact us. You can email glc@albanylaw.edu. Thank you.